Hello, everyone. Welcome to Court with Krissy. Here are 4 court shorts you probably didn't catch. Because who does not love an uncle who wants to be a lawyer? Firing your 4th attorney, getting railroaded because you made 198 calls to the victim, and finally, Brink not showing up and her child support increasing. I hope you like it. No, actually, I hope you love it. Court with Krissy is now in session.
And all others. That's Ms. Barksdale's case. Did we continue this case, Ms. Powell?
No, ma'am, we declined to continue.
All right, anyone here on behalf of
appearance.
Riverdale MHP?
I'm here.
Okay, who said that?
Good morning, Your Honor. My name is Kadisha Mortimer, defendant and counterclaimant in this matter.
All right. Did we hear anything from Ms. Barksdale's office?
No, ma'am. I'm double checking my email, but there's nothing in the record.
I didn't hear anything, Judge, and that's unusual that she have not appeared.
Yeah, because she appeared the last 2 times. All right, so you got Ms. Mortimer, let me see you.
I'm sorry, what was that?
I need to see your video. Do you see you on video?
Hey.
All right. Hello. So this is the last case on the 10 a.m. calendar. So there's a pathos, dispossessory, and a counterclaim. So, ma'am,
dismiss this case since she didn't show up, not yet.
Sir, if you're going to participate in the hearing, then I need to see you. I don't need to have somebody just whispering to Miss Mortimer. Well, I have Miss Lachey. So, are you going to participate?
Because I set this up so she can have a Zoom call. So she's
But if you're tech, then be tech. But if you're going to be tech and legal, then let me see who you are.
Okay. How you doing?
All right, so sit down. Are you the all others?
No. I'm her uncle.
Okay, well, then I'm gonna need you to be an uncle and not a lawyer.
Excuse me?
I said I'm going to need you to be an uncle and not a lawyer.
Well, okay. I just told her if the lawyer doesn't show up, then move to dismiss. That's it.
She can't move to dismiss. She has a counterclaim.
Yeah. Okay. But the lawyer didn't show, correct?
I'm clear on that, sir.
Okay. I mean, you the queen. I'm just,
I'm not the queen. I'm just the judge who has 30 years of legal practice, and I'm just wanting to get on with this hearing.
Yeah, I'm just walking through. I'm just trying to tell her I didn't even hear everything. I just heard somebody not here. I'm just walking through. We had a death in the family, so we're all here. And
so did I, sir.
Yeah, so I was just being nosy. Sorry about that.
All right, thank you.
Have a blessed day.
You too, sir. All right. So are you Miss Lachey or Miss Mortimer?
My middle name is Lachey. My last name is Mortimer.
Okay. So now, Miss Mortimer, it is my understanding that you all were here before. One of y'all showed up, the other one didn't. It appeared that maybe you didn't get notice, so we scheduled the case again. So this is the reschedule of the case that was on the calendar before. Is that what you understand?
Yes, correct.
Okay. All right. So the claimant for the dispossessory has not appeared, but you are here and you are seeking a counterclaim, and you say that your counterclaim is worth $466,000.
No.
Correct.
All right. So tell me why that is.
All right. 1 second. I would like to speak without interruption. I have wrote some things down, so just bear with me. I'm sorry. And you said why did I do?
Okay, let me just explain something first. So we don't just give money just without a basis, especially on a dispossessory. So there has to be a basis for what you're asking for. $466,000 seems like quite a bit of money, and I assume that this is an apartment community. So it's not like a standalone home that was totally destroyed by fire or some other catastrophe. So you're saying that you're entitled to $466,000, and it lists on here $25,000 per violation. That's not how we do it. So now tell me what happened and what you feel you're entitled to.
So it started off with the damages, trespassing, the mold, violating
Okay, one
the
thing at a time.
okay. So it was the damages.
Ms. Jones, I'm gonna need you to mute.
I'm sorry, who was Jones?
I don't know. Ms. Jones, are you a part of this hearing?
Yes.
Okay, who are you, ma'am?
If I could interrupt, Your Honor, my name is Paul McCarthy. I represent the defendant in the case that's set for 11 o'clock, and Ms. Jones is the plaintiff. It was set for her counsel's motion to withdraw. So she's not here on this case. She's here on the 11 o'clock case, Ms. Jones.
Ms. Jones, can you mute for me? This isn't your case. All right. Okay, so ma'am, when did you move into the apartment?
Sorry, I'm bad with dates.
This is your case.
Yeah, I'm bad with dates. But May 31st, 2004. I'm sorry.
2004?
Yes.
You've been living there for 20 years?
No, 2004. 24.
You said 2004. Okay, so you moved in on May 31st of 2004. What was the rent that you were paying?
$1,200 plus utilities.
Okay. All right. Was there a point at which you stopped paying rent?
You said, was there a point?
Yes, ma'am.
Yes, I did.
Okay, tell me when that was, and then tell me why.
One second. Let me check my email. 1 second, okay? It's loading. I'm so sorry.
Okay, can you tell me why you stopped paying rent?
Because of the conditions in the home, which I
Okay.
have proof of the pictures. Would you like to see it?
Oh, no, ma'am. One thing at a time, ma'am. It works best because you're kind of all over the place. So if I guide you through this, it will work better.
All right.
All right. So now tell me, what was the first thing that you noticed that you thought I shouldn't be paying rent for?
Judge, I'm so sorry to interrupt. Could we
Yes.
please take a moment in the breakout room, you, myself, and Ms. Val?
Okay, 1 second. Ms. Mortimer?
Yes.
So my staff attorney checked Odyssey where notices went, and because you're pro se, you probably got a mailed notice, but the attorneys are supposed to get it electronically. And there's something going on with Odyssey where the notices went out, but it doesn't show that Miss Barksdale got notice of this hearing. And it's the same thing that happened last time, only it was, I think, you who didn't get notice of the hearing. And for some reason, we're having these issues with our electronic filing system called Odyssey. I'm going to send paper notice to both of you and electronic notice, but we're going to have to put you on another date. But this is what I ask you to do. Hold on, Mr. Thompson, I'm going to come back to you. This is what I ask you to do. Anything that you will have to refer to, just print it out. Like if you have emails that are relevant to what you need, if you have pictures, have it all laid out in front of you, and then sort of have a timeline of what it is happened and what it is you're asking for. You got me?
Yes.
Okay, so you're organized, but you don't kind of know how this all flows. And so I want you to be able to present your case the best way possible. So when you do that, just make sure you have everything printed out, have it in the order that you want to present it. And the way I'm going to ask for things is I generally start with, when did the lease start? What were the terms of the lease? Like, what were you paying? When was it supposed to be paid? Who was responsible for maintenance? That kind of thing. And then you can tell me, why you felt like you shouldn't be paying because of the issues that existed. You got me? Okay, so now watch your mail. We're going to send you notice. We're going to send Miss Barksdale notice, and we're probably going to have to send that by mail because of the glitches with Odyssey. We'll probably have to do both. Okay? All right, ma'am.
Yes, ma'am.
When you get the notice, like I said, just have all your stuff laid out, and then we'll go through it.
All right. Thank you so much for that.
Thank you. No problem.
All right.
All right. And
May I be dismissed?
Yeah, you're excused at this time. You're going to come back for another date. You're not dismissed like your case is dismissed. I don't have it right now.
Yes, ma'am.
I just set it on what is my next available civil case calendar, but I got a couple that are full, so we'll see what the next one is. Are you in school?
All right. No, ma'am. Oh, thank you, but no.
No, because I just like to, if you're going to be away at school, I want to make sure I can accommodate that also.
Yes, ma'am.
All right. Thank you.
All right. Thank you.
We are here in the matter of the people of the state of Michigan versus Muna Muhammad, case number 24-05148-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on counsel's motion to withdraw as counsel. I see. And we've got a trial date in this matter, September the 2nd, although we'll note here I just had a extensive motion practice on another case. I don't know if it's older than this case or not. That's also up on September 2nd. So this isn't the only thing up on September 2nd, but it's one of my cases up. We're on the 11th hour before trial. But in any case, Ms. Burke, would you place your appearance on the record?
Tiffany Burks on behalf of the people.
Thank you. And Mr. Schmiel, would you place your appearance on the record, please?
Yes, Your Honor. May it please the court. Marcus Schmiel, currently on behalf of Ms. Muhammad.
All right. Mr. Schmiel, I did review your motion here. It appears that there have been some breakdowns in communication between you and your client. However, if I order you to try this case, other than those breakdowns that you described, i.e. that some failure perhaps to file some pretrial motions, are you going to be able to show up on September 2nd and present a case to the jury?
Well, Your Honor, just a little background. At first, just to clarify, Ms. Muhammad filed this motion. I just filed a document in correspondence with that, with agreement with Ms. Muhammad on this. September 2nd, I do have a date certain, which the court, I believe, is aware. You may have forgot. I know you have a lot of things going on in Muskegon County on a CSC first 25-year mandatory minimum. And I had to adjourn another trial due to that. I did speak with court staff regarding that as well. So I don't know exactly what's on the court's docket. If the court says this is the only trial, fortunately, I can't be here regardless. I'm familiar with the material. As far as the case goes, it's not an overly extensively difficult case. Ms. Muhammad wants me to file a motion. I don't believe under the current case law, and I've spent a significant amount of time going through this to see if there was any sort of angle to be able to file something with the court. I cannot find that. I believe that that would be a frivolous motion. I think the court could probably take judicial notice. If there was some kind of issue here, I would absolutely file it. I file motions frequently. It's nothing against Ms. Muhammad or anything else. I don't believe that the issue in this case has merit. I think it's a question of fact, and unfortunately it has to go to a jury. Ms. Muhammad has a different opinion based on that. I further instructed her about what I need to try the case. She doesn't want to give me that information. That's fine if she would like to do it differently. I would note that I am the fourth appointed attorney. I think I did speak with Mr. Beeson. I thought he was entered an appearance of the Register of Action appears that Mr. Nunzio withdrew. Ms. Muhammad was going to hire Mr. Beeson. Mr. Beeson didn't have any information about that, but it wasn't the ROA. So I believe I'm the fourth attorney on this case, not the fifth, because I don't believe Mr. Beeson ever entered an appearance on that. So I would state I did file that with my response. That is incorrect. I'm not the fifth. I'm the fourth.
Okay.
However, I can go on as whatever the court wishes for me to do or whatever discussion.
No, I think I have heard enough to understand the situation. Miss Muhammad, anything you would like to state regarding your plans? First of all, first and foremost here, are you asking me to remove no, you're asking for new appointed counsel because that's what it says on your letter. So you don't want me to remove Mr. Schmiel because you've hired someone.
Incorrect, Your Honor. I haven't hired anyone yet. I want to first and foremost say there has never been a conflict of interest. This should have never been before you. I've let all the other attorneys know as well. A motion for remand to district court should have been filed. As I told my previous attorney that there was no knowing waiver of my prelim. I have no background, criminal background, so my prelim was never explained to me. I was at work when my prelim was waived with Mr. Likens. And no video was watched to confirm that there was an unmarked police vehicle and that the elements for the felony could not be proven even at a probable cause standard. I had talked with Mr. Shamel about a suppression motion, which is a legal question and not a question for the jury, but no substantive conversation or action has been filed on this. I've also mentioned to remove court services when I met with Mr. Shamel as a bond condition, and no further actions was taken as well. Mr. Shamil at this point does not have the best interest on my case. With the lack of communication, I have the email trail. He does not want me to, phone calls. He just want to email. I sent him numerous emails to go over our defense for trial. He has not responded back to me. Along with that, he needed my witness list 21 days prior to trial. I've given him my witness list. He has not subpoenaed none of my witnesses. And then he's been throwing guilty accusations on me as well. And if the courts grant this motion today, I will need, a new attorney. I'm just looking for adequate representation at this time, sir.
All right. Well, and here's my issue. And you've gone through a bunch of attorneys, some of them appointed, perhaps, as well as, some contact and conversation with Mr. Beeson. I always say, when we've excused a bunch of, competent attorneys, I see Mr. Kasork on the list there. There should be a point where you say, gee, is that these attorneys who have cumulative, 50 years of legal experience telling me maybe this isn't going to work, or, am I wrong about it? And there's something to what the attorneys are telling me, and I need to deal with the case under those parameters. It sounds like you think, maybe this case can get kicked entirely. I don't have any opinion on it. I haven't read a single fact on the case yet. I can tell you, well, even if you got that remand to district court and the prelim to run, that standard is, so lenient that your chances are pretty low of not going in front of me. And if attorneys are telling you that's unlikely to happen, and that your waiver appears to be knowing and voluntary, even if you were at work, and first, generally, if you're represented by an attorney and you have some sort of contact with the attorney before waiving that prelim, that qualifies as knowing and voluntary, absent some, extenuating circumstance. You're in the hospital and heavily sedated, being a good example of being, and of course you couldn't make a knowing waiver under those circumstances. But I'm just giving you an outline here of some some reasons that I'm sure attorneys have probably given you as well. And I think, if I do appoint this new attorney, it is a straightforward trial. I'm going to keep, it doesn't look like I can go forward with the trial date on September 2 anyways. And I'm going to tell you, this is the last attorney. And, you can, the two of you can be going, for 3 rounds in a cage match, and that attorney's still going to represent you at trial. So it's on you. Make it work. If that attorney tells you some of the same things the prior attorneys have, I'd say, boy, maybe it's time to say, when these attorneys all think and answer the same way, maybe there's something to that, and I just need to go forward with what I got here and engage in the process, because I can't delay it any longer. The case is simply getting too old. So what I will do is I'll grant Mr. Schmiel's, I'll grant your request for a new attorney at this time. I'll get one appointed post haste. I'm going to set a new trial date of October the 6th, 8:30 a.m. in my courtroom. And that will be with that new appointed attorney. I'll get that person appointed, and they'll meet with you post haste. But like I said, there aren't going to be more attorneys, because what the other net effect of me constantly appointing new attorneys is, of course, the new attorney needs some time to meet with you, read the case, etc. And that delays these cases. I do have a deadline that I have to process these within, and I've got to, however the case winds out, guilty, not guilty, dismissed, etc. I got to bring it to a conclusion within those time guidelines that I'm set. So there will be no new attorney. It's a random drop, at case management from our board. Have you been represented by the defender's office, Ms. Muhammad?
Yes, Nicole is who I've spoken with, and she's who's appointed me with Mr. Shamil. She's is the one that was a little bit helpful, that was pretty much explaining to me what a prelim is, because of all my other attorneys never explained what the prelim was, and never, when I said, can we go over our my discovery, go over the dash body cam, and explain that to them. They've never watched it. The first thing they do is to offer me a plea deal. And like I mentioned, yeah.
First,
I can give you the whole background of this, if you want the attorneys, and nobody from the defender's office, well, the defender's office is represented with me.
Well, I was just wondering, maybe we should give the defender's office a bite at the apple, although that's up to them if they can handle it with their caseload. I don't see any reason why the defender's office couldn't. The only thing is, I appreciate about that is they got more lawyers. They got some ability to spread around cases a little bit and assign them. So maybe we'll give Julia Kelly in the defender's office a bite at this particular apple. But whoever it is, it's going to be the last attorney that I'll appoint to represent you. So
Okay.
I will make a note in the file here that the defender's office, if they have the resources, is an option.
Thank you.
Thank you.
Thank you, Your Honor.
Sure. Have a wonderful day.
Marcus, would you mind
Yes.
sending me an order?
I will draft one. I'm getting it right over to you.
Okay, thank you.
Thank you.
Have a great day.
I would hate that though. Like they do some stuff.
On the record in the matter of the state of Michigan versus Tyrone Howell, 25-032357 and 2382. Appearance, please.
Good morning, Your Honor. Abigail Wilson on behalf of the people. Hey, good morning, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Howell. Mr. Howell, please stand up. Thank you. Who is present stands to my right.
Mr. Howell has a preliminary examination on one file that has a home invasion. Third, the other file has an unlawful imprisonment, 2 counts of assault with intent to rape Arlie and a DV. Third. Are we proceeding today?
Thank you, Your Honor. At this time, the people are requesting a good cause adjournment on both files. Both files involve the same named complainant. While I was preparing for this case last night, I checked some jail calls. I found approximately 198 calls to the victim's phone number. It was registered in the jail system to the victim. A good chunk of them came from Mr. Howell's jail account. A good chunk of them came from other inmates' accounts. Given the volume of them, I was not able to go through all of them. So at this time, the people are requesting some time to be able to investigate that.
198 calls or 188 calls suspected to be to the victim?
198 calls to the victim's phone number. A good chunk of them from Mr. Howell's account, a good chunk of them from another account that I suspect Mr. Howell was using.
Counsel.
Thank you, Your Honor. We'd be objecting to that. Mr. Howell is in custody and being held. I have not been presented with any of these alleged calls, any call logs, any recording. At this time, we are ready to proceed today. We were anticipating and ready to go forward today, so we would be demanding at this point to start the exam and to move forward. Thank you.
I would demand that there wouldn't be 198 phone calls that we need to investigate. It doesn't sound like that's gonna turn out in my favor. I don't know why there would be even the allegation of a phone call when you're advised not to have contact directly or indirectly with a protected party. And then while you're sitting in the jail, which advises you that this call is recorded, that there would be phone calls made on a recorded line. You got to be a weirdo to do that. Or an idiot. One of the two. Only a weirdo or an idiot would do that.
Yes, ma'am.
Especially when violating your bond is a contempt of court order. You can face up to 93 days per violation. So the request to have this case dismissed is going to be denied. If there was 198 calls, it's a large chance that there's been some witness tampering. But an investigator now needs to be assigned, and that's going to take the investigator countless hours to listen to 198 calls because they're recorded, so they know exactly what was said, and then figure out how this matter can be resolved. So until then, to safeguard you, I'm going to suspend all of your phone call and video privileges, all, okay? You're not to use any phones while in custody. You understand that?
Yeah, ma'am.
Your Honor.
Yes.
With regard to that, is he still able to have communications with myself, like the smart jail system?
Yes.
Thank you. If we do use that. You would also ask for a bond because bond reduction due to the nature of the fact that he's still in custody on this.
I don't know how anything that I just heard like furthers the request for a bond reduction. 198 alleged calls to the victim is not like a good baseline to say, hey, I want to get a reduction in bond. Actually, what I'm doing right now is restricting some of your liberties if you haven't noticed. So the request to reduce the bond is denied.
October 2nd at 10.
October 2nd at 10.
Is there any date earlier, Your Honor? I know that.
October 2nd at 10.
Thank you.
That was the earliest date we had.
I understand.
You don't just go pick stuff out months later for fun.
I understand. You said 10 a.m.?
Yes.
Thank you.
Any additional matters for the record?
Not for people. I would just ask that obviously any evidence that is procured or produced, they turned over as soon as possible, so I maybe.
Absolutely, I would hope. I don't know how long it takes for them to go through 198 calls, though.
I understand.
The alleged already.
Stop.
And I feel like I'm being railroaded here. I'm innocent. I haven't done anything. I'm being held up. I'm a father, a parent. My kids got school. It's hard on the mothers already as it is. And then these people are saying that I haven't done anything. So why am I still giving? I'm saying that she got a statement of the alleged.
Stop.
Okay.
I'm trying, sir, I'm trying to protect you from saying anything that can be put under in the record.
Of my innocence.
Would be against my advice that you make statements.
That's up to you if you want to make a statement. That she's advising you. I don't get to tell you what you can and can't say. If you want to waive your right to remain silent, you can do that, understanding that anything you say can be used against you.
Yes, Your Honor.
And these are two separate files. with very serious allegations, sir. These are not,
And I believe there's a third as well in front of Judge Flores.
a third file.
Third felony file, same victim.
Yeah, and then these are serious counts. You're being charged in one of the domestic violence third offense.
Yes, Your Honor.
Was you a father
I've
in the
been-
first and second offense?
I never did any.
Were you
I
a
was
father your
yes,
first?
Your Honor.
Then you got
No,
two.
I
You got
haven't
two
been in trouble
convictions
since-
for domestic violence already.
I haven't been in trouble since.
3
2015, Your
files.
Honor.
3 files. 3 felony files with the same victim and 198 calls.
And a fourth controlled
In a
substance
sense
file.
of, so I can make up a story.
So
I'm saying, can anybody make up a story and just
Oh, so everybody's lying on you.
100%, Your Honor?
Got it. You're all set.
Thank you.
I will get you the rest of the information as soon as I have, okay? I understand.
Do you still have, you want to bring up Dorothy?
Anybody else coming in?
No, not, there's nobody else in the waiting room right now.
Right.
There are a few other people. There's a Kathy B here too.
Or Chelsea Brink.
Chelsea's actually here.
I don't see her name.
Well,
Your Honor,
yes, good morning.
I have tried to contact Chelsea. It appears her phone may have been disconnected, so I'm uncertain of what's going on.
All right, well, we'll just call the cases and see where we go from there. So, but thank you for the information. All right, the first matter on the court's docket this morning. Oh, by the way, welcome. Good to see all of you. Thank you for being here today. The first matter on the court's docket is Devin Hildebrandt and Chelsea Brink. That's file 11-14050-DS. This is scheduled for a friend of the court petition and hearing regarding ordered on arrears amount and also a show cause amount. I do see Mr. Hildebrandt is with us. Mr. Brown just informed me that he's tried to contact Ms. Brink and was unable to as her phone appears to have been disconnected. Ms. Kraus, have you had any contact from Ms. Brink?
I have not, but she did report a new employer on August 15th.
Are we getting income withholding from her?
We are not receiving income withholdings. She did make a payment that dispersed to 2 of her cases on July 22nd. $43.37 was applied to this specific case based on the disbursement policy.
All right. Mr. Hildebrandt, have you had any contact with Ms. Brink recently?
No, sir. Besides, my daughter had a little bit of contact with her, but that was probably the end of it.
All right. Did you receive the small payment that's been made recently?
Yeah.
All right. What I intended to do today was to find out if she'd made a payment, and if she did, to continue the case till next month to make sure that she continues to make payments. But I also wanted to set an ordered on arrears amount because she owes you quite a bit of money in back child support. And she's not got a specific amount that she's supposed to be paying on that. Ms. Kraus, could you, I know I've read your petition. You're asking for $197. I'm sorry, $99 a month to go towards arrears. Is that correct?
It is, and I just wanted to mention in regards to line 3 that it indicates the court would use discretion when determining that amount as the plaintiff's sale of their home and payment history would be considered.
Yeah, I do recall that. It's my understanding, my memory that she received about $37,000. Is that yours, Ms. Kraus?
I do believe so, yes.
All right, so she got about $37,000 according to her testimony last month when we had a hearing on this. And it's my memory also that she spent all of that on purchasing vehicles and staying in hotels as opposed to giving any of that to child support. Mr. Hildebrandt, did you receive any of those funds from her sale of her house in child support amounts?
No.
All right. Under those circumstances, I believe that an additional amount is appropriate over that. At $99 a month, she owes Ms. Kraus, is the dollar amount of $10,800 or 801.42, is that still accurate relatively?
That is accurate as of July 11th.
All right, so it might be a month's worth more than that, but so that's going to take, by my math, it's going to take 9 years to pay off at $99 a month. So I'm going to up it to $150 a month because she had those dollars available to her. She may have spent them now, but it's clear to me that she didn't spend them on child support. So we're going to set the order on arrears amount at $150. Still going to take her approximately 6 years to pay that off at that rate, but at least it's something that Mr. Hildebrand can get while the child is still in the house with him, as opposed to wait until the child is too old to do anything with it. So we'll set it at that amount. She's failed to appear, but she had proper notice of today's hearing. So that amount will be set on the ordered on arrears amount, and then we will adjourn out the show cause for another month to make sure she pays. If she doesn't pay next month, please let me know. We'll schedule this for next month, and if she doesn't pay, we'll do a show cause on that, or actually I'll consider contempt at that point. Any other questions that you have, Ms. Kraus?
I do not. Thank you.
Mr. Hildebrand, is there anything else that we can do for you, sir?
No, sir.
All right. Appreciate you being here. Have a good day.
Thank you, too.
All right. While we're on the matter of Chelsea Brink, let me call up the other case that she has as well. This is the matter of Chelsea Brink and William Mason, file 13-15199-DC, set for a order to show cause on monitoring her payments, as well as an ordered on arrears amount. Do not see Mr. Mason present with us. And Ms. Brink, we just had a case on in which she failed to appear. Her attorney did not have any contact with her. Tried to call and the number was disconnected. The other respondent parent had no contact with Ms. Brink as well. The friend of the court had no contact with Ms. Brink. Ms. Spillane, have you had any contact with Ms. Brink on this matter?
No, sir.
All right. Has she made any payments on this file in the last month?
We received $50.63 in July, but nothing yet for August. But as the previous caseworker reported, she just did indicate she has new employment, so the income withholding order hasn't taken effect just yet.
All right. It has been sent out, however?
I believe so. I'll double check real quick.
All right. All right. Given the fact that she has made a payment within the last month or so, I'm simply going to adjourn the show cause to see if she makes her payment for this coming month. If she does, I won't hold her in contempt. If she doesn't, I will. As to the ordered on arrears amount, the request from the friend of the court is for $101 of overdue arrears, which is 1/2 of the current monthly amount. I'm going to change that to $150 a month, as I did in the other case, because at the last court hearing that we had, Ms. Brink indicated she had received $37,000 earlier this year from the sale of her home and made absolutely zero payments and $0 towards her ordered on towards her arrearages, which in the other file were $10,000, which in this file is in excess of $13,000. For that reason, I'm going to up the payment to $150 because that $101 is going to take in excess of 133 months, which is almost close to 12 years, which is way too long to repay. So even at 150, it's still going to take her 8 or 9 years, which is quite a lengthy period of time to repay a debt. But at least it gives us a chance to have the child to still be in the home when the arrears amounts are received. So we'll set the arrears amount at $150 a month, and then we'll adjourn the show cause to next month to see if she's made her payments. Anything else we can do today in this case, Ms. Spillane?
No, sir.
All right. Thank you very much. That's all for that case.